Major breaking news involving gun right groups that seek preliminary injunctions, specifically the U.S. Supreme Court today in the case of Lackey versus Stinney out of the state of Virginia, decided that you cannot get your attorney's fees as a prevailing party under federal statute 42 U.S.C. 1988 unless you win a final judgment. A preliminary injunction victory is not enough if the case is subsequently mooted out by, let's say, anti-gun politicians. Let's break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, and a member of the U.S. Supreme Court Bar. All right, folks, we got to get right down to it today. U.S. Supreme Court decision, major decision involving 42 U.S.C. 1988. Why should we care in the Second Amendment community about this federal civil rights statute? And that is because when our gun right groups' friends, when the Firearms Policy Coalition, when the Second Amendment Foundation, when the Gun Owners of America, when the California Rifle and Pistol Association, when the National Rifle Association, when all those other related gun rights groups bring lawsuits in favor of our Second Amendment rights against nasty anti-gun laws, gun control laws across this great country, if they get a preliminary injunction in favor of the Second Amendment, that alone will not entitle them to their attorney's fees under a federal civil rights statute, 42 U.S.C. 1988. Just to jog your memory, the way it works is this. There are a series of federal laws, 42 U.S.C. 1981 through 1988. Most of these were enacted in the late 19th century after the Civil War to allow for the vindication of the civil rights of American citizens, in particular the freed African American slaves, to bring lawsuits to vindicate their civil rights against states and localities that were violating constitutional rights. This was then extended in, I believe, the early 1970s or so, by adding a particular statute that said that those people that prevail, that become the prevailing parties, meaning the winning parties in lawsuits, under those federal civil rights laws that were enacted in the 19th century, if they win and become the prevailing party in those civil rights cases against state and local governments that have violated someone's First Amendment rights, that have violated their Second Amendment rights, that have violated their equal protection rights, whatever it might be, then the lawyers that brought that case get their attorney's fees on behalf of their clients, the prevailing parties in that lawsuit. Now, Second Amendment proponents have won attorney's fees over the years in many cases because they have vindicated their clients' Second Amendment rights and became the prevailing parties. Now, here is where it gets a little tricky in this Supreme Court case today, and Lackey versus Stinney plays a role. As you know, in many instances, civil rights lawyers, including Second Amendment advocates, will sometimes seek a preliminary injunction against the state or local government, saying that we don't think you should be allowed to enforce this allegedly unconstitutional law during the pendency of this case. Because we are likely to prevail, we're likely to show the gun control law today violates our Second Amendment rights, or we are likely to show that that particular law suppresses First Amendment free speech, and therefore that law should be enjoined and not enforced during the pendency of this case as it moves its way through the court system, ultimately to hopefully a final judgment in favor of the Second Amendment and the First Amendment. Now, what's happened here, and this is why it's important to understand, what sometimes happens is you get these lawsuits in favor of the Second Amendment or in favor of defending the First Amendment, and then what happens is a preliminary injunction is entered in favor of the Second Amendment or in favor of the First Amendment against the government actors. And then what do those government actors do? They go, "Mother, may I," begging to the state legislature or to the town legislature or to the city council or whatever it might be, or to the zoning commission, whatever it is. And they say, "We're going to get our butt kicked in this litigation. We already have a preliminary injunction preventing us, the government, from enforcing this law that violates the First Amendment or violates the Second Amendment. Therefore, we want you, legislature, zoning board, mayor, city council, whatever it is, to change the law to moot out the case, because if this federal case becomes moot, meaning there's no longer an actual live case or controversy, the case is dismissed as moot because the federal court doesn't have jurisdiction to hear the case. So what will happen is there will be a lawsuit filed, a preliminary injunction sought to enjoin the law, which means to stop the law from being enforced. A court will enter a preliminary injunction against the government. And then, rather than allowing that case to go to a final judgment where the Second Amendment plaintiffs or the First Amendment plaintiffs, let's say, win the case, instead, the legislature, city council, whatever it is, they pass a law that removes or otherwise changes the law in such a way so that whatever relief the plaintiff is seeking, it goes away and the case becomes moot. You may remember this happened actually at the United States Supreme Court level several years ago before NYSERPA versus Bruin in 2022. Before that, in 2020, as I recall, there was another NYSERPA versus the City of New York dealing with the City of New York's gun control laws. And when the Supreme Court granted cert in that case of NYSERPA versus the City of New York, the State of New York and the City of New York realized they were going to get their butt kicked by the U.S. Supreme Court. They changed the law to moot out the case. So therefore, the downside to today's decision is if a Second Amendment plaintiff gets a preliminary injunction in favor of the Second Amendment, and then that legislature for the state or the city or the town or whatever it is changes the law in favor of the Second Amendment, it will moot out the case before there's a final judgment. And when that happens, the lawyers for the Second Amendment or the lawyers for the First Amendment or the lawyers for the civil rights plaintiffs, whoever they may be, whatever they're arguing, will be denied the ability to collect their attorney's fees because the Supreme Court just said that if you don't get a final judgment at the end of the case that says you win, you're the prevailing party, you don't get your attorney's fees under the statute, well, that could potentially be bad for our gun rights groups. The reality, of course, is, as we've talked about before, I think the gun rights groups have now learned, don't seek preliminary injunctions as a general matter because you're not going to get them, and all you're ultimately going to do is delay the case. Better to rush out there and get a final judgment. So as a practical matter, one wonders if this is going to be a big deal for Second Amendment plaintiffs because we now know that you really don't want to seek those interlocutory appeals and those PIs. You just want to get a final judgment. I think this is something I've been stressing for the last year or two on the Four Boxes channel, and I think that message has gotten across to various Second Amendment proponents. I'm not saying I'm the cause of it, but I suspect that I helped influence the waters in which they swim. So the good news is I don't think they're seeking preliminary injunctions anymore, so this case of Lackey versus Stady may play less of a role. The bottom line is what the Supreme Court said, if they're holding here, was that if you look at the text of the statute 42 U.S.C. 1988, it specifically talks about a prevailing party, and at the time the statute was enacted, a prevailing party was someone who actually won a lawsuit, got a final judgment that says you got what you asked for, the remedy you sought, you got. And number two is with respect to who you sued, they lost. And now your relationship vis-a-vis the government entity, either the city, the state, whatever it is now you get something that they didn't want to give you, and that makes you the prevailing party on a final judgment. And that's how the statute is written, they said. And they said if you look at the definitions in dictionaries that were in place, or contemporary dictionaries at the time the statute was enacted in the 70s when this 42 U.S.C. 1988 prevailing party attorney fee provision was enacted, that is exactly what it meant. A prevailing party was someone who actually won a lawsuit. And again, if you win a preliminary injunction, but then the case is dismissed on mootness grounds, your final judgment will say, case dismissed on mootness grounds. It doesn't say that Mark won the case or Bob won the case or Sally won the case. It says case dismissed on mootness grounds. And the Supreme Court today said that does not make you a prevailing party. A preliminary injunction success doesn't make you a final judgment success because, of course, preliminary is just interim. And the key is for a prevailing party to be a final, ultimate prevailing party in a final judgment at the end of the case. And a preliminary injunction is not at the end of the case, and therefore you're not a prevailing party as defined by the statute. So there you go, folks. Hope you learned a little bit something here today at 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner. Don't forget to subscribe. We're closing in on 200,000 subscribers on YouTube, and I appreciate your support in getting me there. And don't forget, we're also over there on Rumble for those of you who prefer Rumble. And I look forward to talking to all of you very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.